Hi, I'm David Fraser. I'm an internet and privacy lawyer with the Canadian law firm McGinnis Cooper. How can you tell that privacy laws are generally written by politicians who also act in the interests of themselves and their political parties? Well, they do it by excluding themselves from any meaningful oversight with respect to the collection, use, and disclosure of personal information. Apparently, one law for thee and another law for me. So there's a bill in front of Parliament right now, Bill C-65, which will impose some greater privacy protection measures on federal political parties, but it simply doesn't go far enough. In the wake of the Cambridge Analytica scandal, we've seen greater attention paid to the fact that political parties have essentially evaded any accountability for the growing amounts of personal information they collect, use, and disclose. There are virtually no guardrails that would prevent a political party from micro-targeting manipulative advertising to specific individuals or communities. But in a limp gesture towards privacy, Parliament amended the Canada Elections Act in 2018 to require political parties to have a privacy policy and to publish it on their website. The amendments still gave sweeping authority to collect, use, disclose, retain, and dispose of personal information in accordance with that privacy policy. It said, quote, in order to participate in public affairs by endorsing one or more of its members as candidates and supporting their election, any registered party or eligible party, as well as any person or organization acting on the party's behalf, including the party's candidates, electoral district associations, officers, agents, employers, volunteers, and representatives, may, subject to this act and any other applicable federal act, collect, use, disclose, retain, and dispose of personal information in accordance with the party's privacy policy. Pretty broad authorization with no guardrails. In the meantime, there's been a lot of action in British Columbia on this front. In 2019, 3 British Columbia residents asked 4 federal registered political parties for information about what personal information they possessed about them, how it was used, and to whom it had been disclosed. All 4 parties actually responded, but the individuals did not think the response was adequate under the province's private sector privacy law, the Personal Information Protection Act. So the individuals complained to the BC Information Privacy Commissioner, which opened complaint files. The organizations objected that because they're subject to the rules in the Canada Elections Act and other federal statutes related to the collection, use, and disclosure of personal information, British Columbia's Personal Information Protection Act does not apply to their personal information practices. And they also argued that a provincial law can't regulate federal political parties. The BC Commissioner delegated the investigation to former Commissioner David Lucadelis, who, as he always does, produced a very thorough report of findings and order related to the jurisdictional point. It's 209 paragraphs long with 261 footnotes. So typical David Lucadelis. He concluded that the Personal Information Protection Act is a constitutionally valid law in respect of property and civil rights and matters of local nature. It's not constitutionally inapplicable to the organizations because of the constitutional doctrines of paramountcy or interjurisdictional immunity. Not surprisingly, the political parties took it to court. They sought judicial review of the BC OIPC's finding and order before the Supreme Court of British Columbia. Earlier this year, the court upheld David Lucadelis' conclusions. So unless that gets overturned on appeal, and it is being appealed, what we're left with is that only in British Columbia are federal political parties subject to comprehensive modern privacy regulation. Quebec scoped in provincial political parties and candidates when it overhauled its privacy legislation, but that's only limited to provincial parties. So right now we have Bill C-65 working its way through Parliament, known as the Electoral Participation Act. It does a bunch of things, and it does move the needle slightly on privacy for political parties, but in my view it doesn't go far enough, and I'm going to explain why. The bill proposes to add a new section 444.4, which is mainly about having a privacy policy, making it available, getting it approved by the chief electoral officer, and then following it. There's some basic things like they have to appoint a privacy officer and include their contact information in the policy. The section then goes on to require that the policy state the types of personal information that the party collects, retains, uses, discloses, and disposes of. D, explain using illustrative examples how the party collects, retains, uses, discloses, and disposes of personal information, such as by indicating whether it does so in the context of online activities or through the use of cookies. Note it says using illustrative examples, not in any great detail. There is some interesting accountability. Oddly, the Privacy Commissioner of Canada has no role to play whatsoever in this, just the Chief Electoral Officer. But violating the privacy policy can result in administrative monetary penalties, which is currently not the case in any of our private sector privacy laws. There are some important and, in my view, problematic ways that this veers from modern privacy laws. It would not require political parties to obtain your consent for their collection, use, and disclosure of personal information. It would not limit their collection of personal information to what is reasonable and appropriate, or even necessary for their operations. They would not be limited in how they can use and disclose electors' personal information. Individuals have no right to seek access to their own information held by a political party, no right to have incorrect information corrected, no right to withdraw consent or opt out from a political party's use of their personal information. The only real guardrails related to fairness of handling personal information is that parties and their minions are prohibited from providing false or misleading information to individuals about the purposes for which the party collects personal information, selling personal information under the party's control, or disclosing personal information under the party's control to the public for the purpose of causing harm. That's not much. Now, full opt-in consent may be unworkable for political parties, but we should at least have better transparency and an opt-out. This is, in Bill C-65, a little bit of progress, but it's not enough. I don't hold out much hope that this bill can be fixed, at least as far as privacy is concerned. But Canadian voters should know more about how political parties manage the vast amounts of personal information they control. And Canadian voters should have a say in how it's collected, used, and disclosed. If you made it to the end, you're likely a privacy nerd and you should subscribe to this channel. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. There's a bell somewhere that you can click to get notified of new episodes. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.